Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick, and Bruno. We've got two questions today, one regarding the CPA or the case of Fenta, and another versus else and another. We'll do the first question with yourself, Bruno, and then we'll introduce the second question a little bit later, which will be more of a group discussion. So basically, there is that case, and the fly notes on this case state that the owners are moving to Australia and selling a property. There's a 3 month notice period, and the tenant is contending that the lease was a fixed term agreement subject to the CPA, and early termination was prohibited. The lease was not entered to during the owner's ordinary course of the business was submitted. The owners do not lease out of property on a continual basis, nor do derive an income. And the CPA, therefore, not applying to the lease agreements. And the 3 months notice validly cancels the lease agreement, and the tenant was then directed to vacate. Bruno, do you want to just touch on the CPA and the application on this case and some of the points that came out about this one?
Sure. For the sake of background, what everyone needs to understand is the Consumer Protection Act typically applies to most supply-consumer agreements or arrangements. And the position has generally been that a landlord that buys a property as an investment property and rents it out simply for the sake of getting an income, even if it's not profitable. It's not about it being profitable. It's in the course of business. At some point or another, this is supposed to be a business. At some point or another, he may want it to be profitable. If he does so, and he does it and this is considered within the course of business as a property investor, then he does become a supplier of goods, because now the tenants become his clients, and the tenants are paying him for the supply of a certain product that he provides to them as a supplier in terms of the CPA. Now, under those circumstances, the position has always been that the Consumer Protection Act would govern the relationship between the tenant and the landlord. Now, just to take a step back, this means that the landlord, in circumstances where he's not a supplier, could potentially not be bound by the Consumer Protection Act. Now, these examples are few and far between, because no one's actually gone through the effort of challenging this in court. And that's the reality. So I've had a few examples, for instance, where if I own a primary residence and I happen to have a cottage and I need assistance in covering my bond, so I put somebody in there just, as a side thing. Maybe there's a potential that I'm not a supplier in the ordinary course because I didn't buy the property with the intention to invest. But it's almost looking at the intention of a landlord and what he intended to use the property for. So an argument could even be raised that if you buy a property for the sake of capital growth and flipping, and you don't intend to actually run a rental business, but you just put a tenant in there simply because you want your bond covered or the expenses covered, arguably, even then, you're not actually a supplier. But the reason why we always erred on the side of caution and told people that the CPA applies is simply because the one big difference that the CPA makes where non-CPA versus non-CPA is the time period for notices that a landlord needs to give for persons in breach of an agreement, and the right that the tenant has to terminate the lease agreement at any point during the lease period, provided or subject to a reasonable cancellation policy. So if one weighs up the pros and cons, is it worth challenging the applicability of the CPA simply to circumvent these two clauses? Probably not, because it seems like a fight that's simply not worth having. We often said, on the side of caution, if a tenant does cancel at any point during the lease, because the CPA is applicable, you know what, there is still a reasonable penalty. Make sure that it provides for enough time for you to get a new tenant, and then there's no real harm, because in any event, that's probably what you'd get without the CPA and the person left overnight. Insofar as your notice period is concerned as a landlord, yeah, you know what, it'd be great to give 7 days notice to remedy a breach. Yes, it is 20 business days notice, but that's it. And if they don't remedy it in 7, they don't remedy it in 20, they're in breach of the agreement and you cancel it. And so all this court case does is, and this is important for everyone to know, because we had a lot of phone calls where people were now either very happy or they were panicked. Does the CPA apply? This is great news. I can now start giving people 7 days notice every time they breach the contract. This case doesn't do anything more than confirm what I've just said, and in fact, only does so in very particular circumstances. So this case cannot apply to everyday circumstances. I'd have to say less than 1% of cases would ever suit the circumstances here. And remember, when case law applies, when you look at it from a precedent perspective, the facts need to be similar if you want to apply the case law as precedent. And here, basically, the landlord had their primary residence, decided to go experience Australia. So they rented the property out, or leased the property out, because they didn't want to sell it. They just wanted it to be maintained. They wanted somebody on it. They didn't want it vacant. They probably just wanted to cover costs, I'm assuming. So they decided temporarily to lease the property, and they went abroad to test out life in Australia. Maybe it worked out, maybe it didn't work out, but the reality is here specifically, when the dispute arose between the tenant and the landlord, and whether the CPA applied, and whether the tenant was allowed to give notice, and what sort of notice the landlord had to give, the question became, does the CPA apply? And the court here simply found, as I stated before, they weren't planning on running this property and the rental of this property as a business. This was a temporary fix while they were doing something else abroad and testing the water. If that's the case, the court felt the CPA didn't apply, and found in that regard. So again, guys, if you want to challenge, this is one of the very few cases on the CPA. If you do ever want to challenge it, is it worth it? But yes, the reality is that there are circumstances where landlord is not bound by the terms of the CPA, and where the tenant doesn't have the rights allowed for in the CPA.
Yeah, so thank you very much on that one, Bruno. I will be posting a link to that case on the caption. But just for background, some of the older points that were given is that the 3 months written notice to the respondent in terms of one of the clauses of the lease agreement was validly cancelled the lease agreement with effect, and the respondent and all those holding title under him were directed to vacate the property before then the end of March. So yeah, that brings us to the end of the first question with Bruno.